I mean, yes, but I mean, it's set for a contested, so it's going.
Well, I wanted to bring something to the court's attention,
Okay.
if I may. Mr. Ross and I, as the court was probably privy to, are not on the same.
No, I made it. No, I made a mistake.
Just 1 second.
No.
Quick hook, hold up tension with counsel on day one. That's the red flag every courtroom vet watches for. Stick around, this gets messier before it gets resolved.
All right. So any questions, defense or state?
No, Your Honor.
Well, here's the thing. We don't shout in court, right?
Right.
You got to be respectful to your attorney and respectful to each other. All right.
End of flashback.
Such that I don't think that it would be productive or civil for me to continue representing him.
I mean, I understand what you're saying, counsel, but we were here in August and it was set for a contested hearing for October 9th.
Mm-hmm.
And then it was reset for today for a contested hearing. So
Right.
the state has their witnesses. We're going to proceed.
I guess I'll say this, if I may. We're not getting along.
Real talk, when an attorney says representation isn't productive, that can trigger substitution or even a recess. What would you do if your lawyer said that in open court? Drop a comment.
I think it's very much affecting my wanting to and desire to represent him, because I don't want to be cowered over and yelled at.
So here's the thing. You can't be yelling at people. That's it. So your attorney is here to represent you. You have a motion to revoke. You're on probation for possession of a controlled substance, penalty group 1, 4 to 200 grams. Your underlying is 8 years. So that means if the court were to find the allegations within the motion true, then you're looking at 8 years. Now, if you want to shout at your attorney, I don't know why you would do that. I don't know why you would raise your voice to your attorney. That's on you. But I can tell you what's in this motion to revoke. Just one moment.
Yes, Your Honor.
Are you the same James Ross Jr. who was placed on community supervision in 2024 CR 008733 for the offense of possession of a controlled substance, penalty group 1B, 4 grams to 200 grams on February 13th, 2025 for a term of 9 years? Is that you?
Yes, Your Honor, I do.
State?
Condition of condition number 2, on or about the first day of May 2025 in Bear County, Texas, the defendant, James Ross Jr., did then and there illegally use amphetamines and violently.
How do you plead to that? True or not true?
True, Your Honor.
This is the key moment. Those violation findings can convert probation into years behind bars. Don't skim past the dates and counts. They are what decide whether someone stays free or goes to prison.
Violation of condition number 2, on or about the first day of May 2025 in Bear County, Texas, the defendant, James Ross Jr., did when there illegal use cocaine in violation of condition number 2.
How do you plead to that? True or not true?
True, Your Honor.
And then violation of condition number 4, in Bear County, Texas, the defendant, James Ross Jr., did then and there fail to report to the supervision officer as directed for the months of May and June 2025 in violation of condition number 4.
How do you plead to that?
Not true, Your Honor. To one of them.
All right,
I
not
did not.
true to which one?
I did not.
Waive violation of condition number 1, 4, and 14, which is
Any objections to the waivers?
None.
Did you understand by pleading true to violations 2 and 2, the court could find it true, grant the motion,
Well, you know what?
and sentence you up to 8 years in the prison and up to $2,000 fine? Knowing that, do you still wish to plead true to violations 2 and 2?
That the court's only option.
No, I'm telling you what you're looking at. What you're looking at for any violation, it could be for littering. Any violation that is presented by pleading true, the court could sentence you to 8 years in the prison. Will I sentence you to 8 years in the prison? I don't know. I haven't heard anything with regards to that. But that is what you're looking at. And what I can tell you, whatever agreement you worked out with the state, if you have worked out an agreement, the court doesn't have to follow that agreement because this is a contract with the court. It's not a contract with your attorney. It's not a contract with the state. So by pleading true to 2 and 2, you are looking at a potentially 8 years in the prison and a $2,000 fine.
Dramatic reaction plus retention hook, 8 years on the table and he still pleads. That's a full-on gamble. We'll watch the judge's reaction next. Major payoff incoming.
Knowing that, do you still wish to plead true to violations of 2 and 2? That's either yes or no.
Yes.
Court will find 2 and 2 true. Is there a proposed agreement?
State is requesting not to grant the state's motion, and of those two defendants can use supervision and sentence him to the 8 years in the prison based on the plea of truth here today, and then based on the underlying facts in the case that he's placed on probation. The state made punishment enhancements through that and recommended change of supervision was done by a prior ACA. And based on that amount that was he's in possession of at the time of the offense and continued use and possession of controlled substance.
All right, defense, what are you requesting?
We're asking for drug treatment, Your Honor. I mean, he's on probation. He tested positive for some substances. It was obviously consistent with use. We all make mistakes. We all have relapses. He was on probation for a drug offense. And he made note to me. He said, the judge told me when I pled that if I ever have problems, to contact the probation department, to let them know, to work with them. And that reflects well on me if I ever came back.
Did he do that? And I'm not considering it because I know the number 1 was waived. However, inpatient treatment is not going to be available for him until...
Defense strategy explained. Defense asking for drug treatment isn't just sympathy, it's a mitigation play aimed at keeping the defendant in the community, not behind bars. Would treatment change your view of culpability? Vote in the comments.
That case is whatever is done with that case.
Her, I should get her off the line.
All right. Any objections to that witness being by Zoom at 1:30?
None.
All right. So, Ms. Abrams, if you'll let her know, we'll be back at 1:30, and if she can look through her files between now and then. All right. We'll see y'all back at 1:30.
Thank you, Judge.
Were you made aware of a warrant for his arrest?
Yes.
Okay. And what did you instruct him to do when you spoke with him on June 9th, 2025?
Once I spoke with the detective and he verified that the warrant was active, I instructed him to turn himself in and handle the warrant to clear it.
Okay. And to your knowledge, was that done? Well, actually, let me rephrase the question. Did you speak with the defendant again on June 12th, 2025?
June 12th. No, I do not have record of that conversation. No.
Okay. Did he ever ask for any help specifically regarding substance abuse?
No.
Okay.
I just want to get some clarification. You said there was a positive drug test on May 1st?
It was May 1st, yes.
And where does that drug test take place at?
He goes to either recovery downtown or he can come here on Mondays and Thursdays here at Bandera location.
Did you please tell us where that May 1st test was taken at?
It tells me RMS, but I'm unaware if it's Bandera location or downtown. I just know that it's RMS.
And what does RMS stand for?
Recovery Medical Services or something like that. Yeah.
Is that the test provider?
Yes, that is. That's where they go and submit their drug test.
Okay. And so what you're saying is that your notes are inconclusive as to whether or not he came into your office in the month of May.
In the month of May, yes. I am unaware if he came here or downtown.
Okay. And when he comes to your office, I imagine he doesn't direct himself. as to what to do when he arrives?
When he comes for a drug test, he's not to check in with me. He's only to check in with the drug test providers when they're here. So regardless, I wouldn't have known if he was here or not because he does not check in with me when doing drug tests.
Okay, were you available that day when he showed up?
I'm not sure if I was available or not. He didn't ask for me or anything. I probably was in a meeting.
Okay, fair enough. Now, my next question is, did you receive a call from him on June 1st?
June 1st. Let me check.
Are you aware of the offense date of the alleged, I think it's new number 1 in the MTR allegations?
Let me check the MTR. I have it pulled up. The alleged date is June 1st, 2025.
Do you recall speaking to James Ross about that new number 1, the day that it happened? Did he call you or speak to someone at your office?
No, not on June 1st.
So my question to you is, do you document any and all communication with the client, or just those that you deem to be relevant?
All of them.
And it's your testimony that you did not speak with Mr. Ross?
All right, could you rate, you're still under oath. All right, you may proceed.
Just one more. Mr. Ross, on the date of the new alleged number 1 against you, did you call the probation department or Miss Dixon that day that it happened?
I did.
Who was with you when you made that call?
Twanya Monday.
Who was Twanya Monday to you?
All right, first of all, for the record, if you could spell the first name.
TWONYA.
All right.
And what date do you recall speaking to Miss Dixon?
Here's the human moment. He calls probation right after the incident. A call can be the single fact that tips credibility in his favor. Think that's enough to save him? Tell us why or why not.
It was the date of the alleged robbery. I believe it to be the 1st.
The 1st of what month?
June.
Is that a 2025?
Yes.
When you called her, did you reach her directly, or were you rerouted to her when you called a general number? How did that work?
I reached her directly. I called to the office.
Okay.